All right, good afternoon, everyone. Welcome to Economic Matters. Today is Tuesday, February 6th. We have 3 bills today. Whenever you're ready, we can get started. I know Delegate Mondari is not here, so we will call up Delegate Todd Morgan and start with his bill. Todd, is everybody from your panel here that needs to be? Okay, so we will start with Delegate Todd Morgan. All right, House Bill 391.
So thank you, Chair Crosby and illustrious members of the E&T Committee. I come here before you to introduce House Bill 391, and with me is John Vanderwert, representing the Diocese of Washington, D.C. The purpose of this bill is somewhat different in that it dates back to an act of 1798, I believe, called the Vestry Act. So in 2024, we're catching up. Basically, the act is going to propose and allow the churches in the Diocese of Maryland and Diocese of Washington to fall under the same corporate rules, excuse me, that the Diocese of Maryland and Diocese of Easton contain. So the Episcopal Church has 3 dioceses in the state: Diocese of Maryland, Diocese of Easton, and Diocese of Washington. The Diocese of Washington is composed of 4 counties: St. Mary's, Charles, Prince George's, and Montgomery. And by a quick tally I did, every delegate, or maybe minus 1, has an Episcopalian church in their diocese. So what basically we want to be able to do here with this bill is to request that the same status become the laws of Maryland and the District of Columbia, because they didn't align. The reason for the misalignment, obviously, is because of Washington, D.C. having its own corporate laws and structures that dioceses of the other 4 counties don't have. Since that time, the law has been aligned, and the District of Columbia now aligns with the 4 counties. So what HB 391 will allow us to do is to have the same corporate status as all the other denominations and dioceses. It provides banks, grant givers, and others more complete information to church status, and allows the Diocese of Washington to operate in a more transparent and open manner. And with me, John Vanderwert here is counsel for the church, if you have some comments.
Thank you, and thank you, Chair Crosby and esteemed members of the committee. As Delegate Morgan said, I serve as the Chancellor of the Episcopal Diocese of Washington. Chancellor is just the fancy term we use in the Episcopal Church to mean lawyer. So I'm the legal advisor to the bishop and to the diocese. The Episcopal Diocese of Washington has 51 parishes in the 4 counties of Maryland that are part of the Diocese of Washington. And the purpose of HB 391 is to make the corporate governance of each of those 51 parishes subject to the same rules that apply to Episcopal churches in other parts of Maryland, as well as other churches of other denominations throughout Maryland. The Episcopal Church has long roots in Maryland. Some of the parishes in the diocese were organized before the Revolutionary War. And in the 1790s, Maryland adopted a statute called the Maryland Vestry Act to govern Episcopal parishes. That statute from 1798 still governs the parishes in the Diocese of Washington, but it does not govern the parishes in the Episcopal Diocese of Maryland and Easton. In 1976, the General Assembly passed a law to change the rules that governed in the Diocese of Maryland. And in 1990, the same was done for the Diocese of Easton. Those bills repealed the Maryland Vestry Act as it applied to Episcopal parishes in those dioceses, and instead made those parishes subject to the religious corporation statute that applies to all sorts of other churches throughout Maryland. We're now asking the General Assembly to enact HB 391 to make the same change for the Episcopal churches in the Episcopal Diocese of Washington. And we modeled the bill text when we worked with Delegate Morgan's office to follow what was done in 1976 and 1990. This will be a great help to parishes in the Diocese of Washington. Under the Maryland Under the Vestry Act, parishes don't have charters or articles of incorporation. And as a result, when they're asked to prove their existence, there's no state office that they can turn to for a certificate of good standing. This would make them religious corporations that have the same ability to do that at the State Department of Taxation, Assessments and Taxation. And several parishes recently have been unable to apply for grants or open bank accounts because of this reason. We also think.
So that being said, ladies and gentlemen, I ask for a favorable bill hearing for HB 391. Thank you.
Delegate Fisher.
Thank you, Mr. Chairman. I just have a quick question about the why now, I guess. I mean, I heard the testimony. The reason I asked the question is because I know Calvert is not part of this, Calvert County. But there's a schism, a pretty significant schism in the Episcopal Church that's been going on for quite some time between the more traditional churches and then the churches that many believe are not following the faith, to put it nicely. Is the purpose of this to rein in control of those churches? Is that really one of the effective results of this?
Thanks for the question, Delegate Fisher. No, the intent of this bill is not to have anything to do with the relationship of parishes to the diocese. This is solely intended to address the corporate organization of parishes as separate entities so that they're able to establish and prove that status in the same way as churches of other denominations.
So if someone in the Episcopal Church wanted, if this bill were to pass, or even if it didn't, if someone in the Episcopal Church wanted to disassociate themselves with the church because of what they believe to be moving away from traditional teachings, could they do so?
There is a process to do that under our church canons that they're required to go through. And we have had that happen in the recent past. But this bill would not change the way that that works.
Thank you.
All right, thank you. And thank you, Delegate Morgan, for bringing the bill. That concludes this bill hearing. Next, we will go to
Thank you.
Delegate Adams on House Bill 487. And I still don't see Delegate Pandari. So we're going to try to make sure we get up here because I know many of you are here for his bill.
Mr. Chairman, can I bring my panel?
Yeah, bring them all up. It's fine. You can start when ready.
Okay. Thank you, Mr. Chairman. Economic Matters Committee. For the record, I'm Delegate Chris Adams to bring House Bill 487. I'm joined today with the panel, Valerie Connolly, Matt Defoe with Chop Tank Electric Cooperative, and Tiffany Harvey with Cornerstone Government Affairs. The bill has to do with capital credits. The Electric Cooperative will issue capital credits to their members. This bill would take unclaimed money, in other words, capital credits that can't be issued to the members, and instead of it going to the comptroller for unclaimed property, this bill would allow that money to retain with the cooperative and allow them to use it for philanthropic endeavors, other projects that are of interest to the membership at large. And we'd ask for your favorable report. Thank you.
Thank you, Delegate Adams, for bringing the bill. Good afternoon, Vice Chair Crosby and esteemed members of the Economic Matters Committee. My name is Tiffany Harvey, and I'm a principal with Cornerstone Government Affairs. I, along with my client, Chop Tank Electric Co-op, am here in support of House Bill 487. The impact of this bill is local, as we believe that non-escheat capital credits held by Chop Tank Electric should be used by the cooperative for the betterment of the local community as well as their members. We ask for a favorable committee report. Thank you.
Oh, sorry. Thank you, Mr. Vice Chair. Valerie Conley here with Chop Tank Electric Cooperative. Our board of directors asked us to bring this bill because, as you guys know, the cooperative is a member-owned organization, and the capital credits that are accumulated over time are the members' investment in the cooperative. And for the few, which it's usually down to about 6% that we can't locate at a time that we retire capital credits, we believe those funds could be best used by the cooperative to do good works in the community or to further some of the things we're trying to do as a distribution electric cooperative. The average amount that we're talking about is just under $200,000, but sometimes it's as low as $1,600. And so those monies we believe can be very meaningful in the local community. Some of the things that we would try to do with the funds, depending on how much it is from one year to the next, are additional tree planting programs, scholarships and workforce development, apprenticeship programs. Sometimes we're asked to do line extensions for Little League and other youth sport fields. And then we often, especially during COVID, had a great number of members who needed help paying their electric bill. And so we try to find ways to put funds into that program. And I wanted to make the point too, not only does Chop Tank, the cooperative, participate in community activities, but so do our members individually. And that's evidenced by the fact that 94% of our members participate in a program where they round up their bill each month in Operation Roundup for community programs. And so we believe this money would be very useful to our members, and we would ask for a favorable report. Thank you.
Thank you, Mr. Vice Chair, members of the committee. For the record, my name is Matt Defoe here on behalf of Chop Tank Electric Cooperative. I just want to say a really simple me too, but just give a quick example or project of how these funds could be used or have been utilized or could be utilized in our community. Late last year, the Purdue Henson Junior Achievement Center was opened in Salisbury, Maryland. Chop Tank partnered with Delmarva Power to develop an educational and interactive energy industrial storefront. This 3-year, $50,000 investment shows only a small part of the commitment to the workforce development, career engagement, and additional educational opportunities the co-op is looking to achieve. 10,000 students will visit this center. I encourage you all to visit it if you're on your way down to Ocean City. But again, these opportunities like the JA Center, economic development, and charitable giving will be always highly considered by our democratically elected board of directors if these funds are able to be used. Thank you. And with that, I ask a favorable report for HP 47.
Thank you so much, Mr. Chair, and to Matt and Valerie, thank you guys as well. Really quick question, just so I can understand this a little bit more. First question is Chop Tank the only co-op that actually will benefit if this legislation passes in terms of using unused credits, unclaimed credits to?
No, all the cooperatives in the state of Maryland would, but there's only a couple, there's two.
Correct.
So.
And then help me kind of understand what is currently happening with the unclaimed credits now.
So any unclaimed credits that we look for the owners. A lot of times we have to try and find estates, because the way the credit system works is when we allocate funds at the end of a year, we figure out how much money it took us to run the cooperative, and any excess funds are allocated back to members. But that stays at the cooperative for a number of years because that's what we use to run the cooperative. Instead of taking out expensive loans, these are monies that the members agree that we're using to finance the operations. But every year the board looks at that amount and says, do we need all of it or can we start to refund it? And so when they make the refunds, they try to go to the oldest amounts that are being held. So many of them are years old, and either people have moved and didn't file a forwarding address or have passed away and their estate has not contacted us. We have a full-time person who looks for these folks on the internet, tries to get in touch with other family members in the community. Again, it's a cooperative, so we're a small, close-knit community, and usually people know where someone has gone. And so we make every effort to try and locate these anybody that we can't find. And then after 3 years of looking, we're required by state law to send that money to the comptroller. And then the comptroller, I believe, also looks for people. They publish that big book, or it's on computer now. But if it's not claimed by somebody, then I think they remit it to the general fund at some point.
Great. No, we're happy to talk offline. This just seems like a really good and meaningful impact to the folks in the community.
Thank you.
All right, seeing no further questions, that concludes this bill hearing. Next, we will go to Delegate Mondari, House Bill 426. Delegate, if you have a panel, you can bring up the panel with you. Yep.
For the record, I'm Delegate Harry Bhandari, presenting here House Bill 426. Chair Wilson, Vice Chair, and members of the Economic Matters Committee. HB 426, which passed from this committee 2 years ago, would require movie theaters to offer open captioning by displaying the written text of the audio content on the big screen. This way they can follow the dialogue and sound effects in real time without the need for a separate device, such as handheld closed captioning device. In addition, open captioning ensures that they have the same access to the movie-going experience as everyone else, improving their overall enjoyment and engagement with the content. Smaller theater might offer a handful of screening per week. Others might offer a dozen or more. I don't think it is an overreach to ask that just to include captions. Frankly, when we weigh the number of people this would benefit against the number it would hurt, it is surprising movie theater don't already do this. And many of the dozens of testimonials supporting this bill focus on its impact on deaf and hard of hearing people, a group that has historically been locked out of a movie going entirely. In recent years, some developments have made it possible for these folks to attend screenings with closed captions on little handheld devices. Still, these have to be proactively requested, can be distracting, out of sync, or plagued with technical problems. Just take a moment to imagine that you are at a movies and there is no sound. You have to glance back and forth between the action on the screen and a little device in your lap or to keep track of what everyone is saying. Does that sound like it is worth the ever higher price of a ticket? Let us remember the vulnerable population in our society. Seniors may struggle to hear every word in a movie with intense sound effects. Would they prefer to read caption on small handheld screen? Or parents who want their children to expand their vocabulary and improve their literacy? Age studies have shown that watching movies with caption can positively impact a child's literacy skills. And what about English learners of all ages who are not only trying to comprehend the dialogue, but also the cultural reference and humor that will help them improve their communication skills? Open captioning on the biggest screen can make these potential customers feel more welcome and included in the movie-going experience. Mother Teresa once said, not all of us can do great things, but we can do small things with great love. Offering open captioning in movie theater is a small step toward creating a more inclusive and accessible experience for everyone, particularly for deaf and hard of hearing individuals who might otherwise be excluded or face difficulties following the audio content. And I request favorable report on this bill. And I have the folks testifying on this bill. Jacob Leffler is the first one.
Yep. Thank you, Delegate Bhandari. And quickly, typically what we've done in the past is had a timer of 2 minutes for witnesses. We're going to take the timer off, understanding the community here to testify. We just asked that keep the remarks brief. And then if you've never, obviously this bill is passed out of the House before. And so it's already moved once. So if a point has already been made, there's no need to, reiterate that same point. But we do appreciate everybody coming today. And so with that, I'll turn it over to the first witness you have, Delegate.
Are we live? Are we hot? Hi, good afternoon. Thank you for your time. It's a pleasure to be here in front of you in support of the open caption movie bill. I want to thank you for the opportunity to speak in front of you. Like our delegate said, this bill will benefit many more communities than just the deaf community. In Maryland, there are over 6 million people who live in the state who are deaf and hard of hearing, and it will benefit those people. This bill also would benefit veterans, folks who lost their hearing later in life, people who want to learn English as a second language or want to improve their reading and writing skills, hearing people who have an issue with background noise. Open captioning gives us equal access. We don't have to feel like there's anything separating us from the experience. It's for everyone's enjoyment. Nobody has to worry about a particular device having an internet problem or not working properly. Now we're going to miss 20 minutes of the movie to deal with tech support, those kinds of issues. Open captioning will solve these issues. This is also a violation of the Americans with Disabilities Act because it doesn't afford efficient communication in a place of public accommodation. So there is no current optimal solution for that. So we request your support in the open captioning. Two times per movie per week. I also want to mention that our team has received over 900 letters from people around the state and all of the counties in support of this legislation. We also received over 25 letters of support from different organizations, including Disability Rights of Maryland, On the Go of Maryland, the Maryland Association of the Deaf, and the Jewish Council of Baltimore, to name just a few. The Archdiocese of the Catholic Church of Baltimore as well. So lots of organizations are in support of this bill. Again, I want to remind you, in the last hearing 2 years ago, the National Association of Theater Owners admitted that there was no charge or no financial impact in turning on the captions and no extra charge. So I want to make sure that you are aware that there is no financial impact of this bill. Hawaii passed this bill in 2019 and New York City passed this in 2021. So I think it's time for Maryland to follow suit and become one of the leaders in this effort. Thank you so much for your time. Appreciate your support on this bill.
Here is Ursula DeBerry from Governor's Office of Deaf and Hard of Hearing.
Hi there, and thank you. Good afternoon, Chairman and honored members of the committee. My name is Ursula DeBerry. It's my name sign. I'm honored to be here on behalf of the Governor's Office of the Deaf and Hard of Hearing as acting director, providing testimony in support of this open captioning bill. As one of many hard of hearing Marylanders in the state, I depend on captioning to watch movies, TV, news, etc. This legislation requires movie theaters that provide closed captioning to also provide open captioning, open caption movies twice a week, as Jacob mentioned. Open captionings are inclusive. They allow all of us to share the same experience together, regardless of their hearing status or language skills. Closed captioning are not always inclusive. Open caption is much better for the entire community. When individual caption devices fail, the user is automatically and immediately excluded from the experience, leading to further isolation and separation from their peers. Based on Johns Hopkins population, their research information found 1.2 million, and this was 2016, 1.2 million, and the interpreters were requesting clarification. 1.2 million people who are over the age of 12 who live in Maryland who require the service. Due to decades-long stigma of revolving hearing loss, not many people are willing to admit their hearing loss to others. Most particularly, age-related hearing loss occurs with senior citizens. Some options lead to increased isolation of individuals and limited conversation with their peers. But with this experience, will increase the opportunity for bonding and help promote better mental health among seniors and other folks. Open captioning is universal design. It benefits everyone. And it allows for the bonding of families and small children who will be able to read what the movies are talking about and text as part of their literacy development. For people where English may not be their first language, they would also benefit from reading and listening at the same time. It would help with the development of their English skills. They might not be able to follow the movie just by audio alone, so the captioning helps. We also have folks in the state who are neurodiverse, including children and adults, who also rely on captioning. So please continue to show your support for this bill. We very much thank you for your time.
Next, we have Tina Joyner, Maryland Association of the Deaf.
Hello, Chair, committee members. Thank you again for allowing me to be here. My name is Tina Joyner. I'm the president of the Maryland Association of the Deaf, representing 1.2 deaf and hard of hearing Marylanders, not just those, but children of deaf adults as well. We call them CODAs. So I've been on this team for the last 2 years and I've seen a lot of changes. I think it's really important for you to continue to support this bill, excuse me. We have been trying to work with the National Association of Theater Owners. They've given us very few excuses. They've avoided us. They've not shared data with us. They've said that it will hurt their business. We've shared a lot of data with them and with you. And I think it's just a matter of looking at the data. And Jacob has all of that for you if you've not yet seen it. Closed captioning now in the movie theaters is not effective for everyone. So just a few examples. You know, they might work and then in the movie, the battery dies. I mean, it's as simple as that. Sometimes the captioning actually hooks up with another movie, not the one that I'm in the theater for. So then again, we have to deal with tech support. We have to go back to the ticket counter and it's a loss of time. It's a loss of money. It's a loss of our family time or our friend time, whoever we've decided to come to the theater with that day. Again, open captioning is a benefit to everyone, including yourselves. Everyone in this room can benefit from open captioning. And that will allow everyone to enjoy the same experience. So I'm asking for your support for HB 246. Thank you so much.
Okay, thank you, everyone. And Jacob, I know that you've been here every year for, I don't know, maybe the last 6 years. So I just want to thank you as a familiar face. It takes a lot to advocate and come back up here each and every year. So thank you. Okay, that concludes this panel. Next, we will go to Kelly Brick. I'm sorry. Sorry. Nobody moved. My bad. Delegate Queen.
Thank you. Thank you, Mr. Chairman. Delegate Bagari, as we mentioned, this bill has come before us and passed out of the House. Has it not passed out the Senate, or there's been changes people want? Can you give me some insight into what has stalled the progress?
Yeah, last year, Senate had a wonderful hearing and they had a summer work group. I don't think there was any outcome, and this year we are in touch base with the NATO. They're offering some amendment, and hopefully we'll pass this bill from the Senate this year too.
Okay, so you don't know what amendments they want yet.
They're still discussing. Leffler, you want to talk about the amendment?
I can. So currently we're hoping to finalize today or tomorrow before the hearing on Thursday in the Senate. But the amendments basically include that NATO wants us to agree on, I think, the final language. So 2 or more locations. We've agreed on that part. Another amendment talks about allowing 3 weeks for open captioning. And after that, the theater can make a decision. So we'd like to make sure that the movie theater will still provide open captioning on request after that 3-week time. And then the First Amendment that they're proposing is that the bill doesn't apply to any movie theater that shows 7 shows or fewer, which means that we only are able to go to movie theaters that are showing over 7 shows. So we want to lower that minimum. And if you don't mind, I think we're on the right track. I think we're closer and closer to consensus. Thank you.
Okay, I think that officially concludes this panel. Thank you guys very much. We have 2 individuals in person left. Kelly Brick. In Prince George's County Association for the Deaf, do you guys have a representative here? Okay. You may begin.
Hello, everyone. My name is Gabriella Davis, and I am representing Prince George's County's Association for the Deaf, and I am their president. And I'm here to support HB 426, the open caption bill. In Prince George's County, there is a large number of Hispanic individuals that live in the county. Their first language is Spanish, not English. Open caption movies will help them learn to write and read and improve their English skills while having fun. They're able to sit and watch the movie. English and Spanish have different word orders. So if you are a Spanish-speaking individual, you may find it challenging to arrange those words in the correct English order. That is a very similar challenge that they experience. With open captioning, they're able to improve their English skills by watching the movies and being able to construct those English sentences in the correct order. Lastly, it would benefit one of the biggest technological resources. And they would benefit from those visual aids. That's a very powerful tool for enhancing and comprehending the movies when they go and watch with open captioning. As the president of the PG Association for the Deaf, I have heard various issues with closed captioning devices, and it is a standard narration that I've heard over the years. The best solution is to pass this bill. So I look forward to the day where we're all able to go and watch a movie together. So please support HB 426. Thank you.
Good afternoon, Chair and distinguished members of the committee. My name is Kelby Brick, and I'm the Chief Strategy Officer for Service Coordination, Inc. SCI is a leading nonprofit organization that provides award-winning case management services and advocacy for more than 15,000 individuals with disabilities, medically complex needs, older adults, and others across the state of Maryland, the District of Columbia, and Northern Virginia. The mission of SCI is to help people understand their choices and to create pathways to community resources that respect their dignity and their rights. The organization also provides companion care and aging life care, as well as aging life management through the Moncordia program. Now, I did already submit my written testimony. You have it in front of you now, and I'm not going to repeat what is in the testimony. I do just want to emphasize a few points. First and foremost, this is a very unusual bill, and the reason being is that it costs the state absolutely nothing. It costs theater owners absolutely nothing. How many times can you say that you've passed a civil rights bill that costs people nothing? That is so vital. That is so important. And really, this is just an extension of the law that you already passed probably about 10 years ago. And that law that was passed 10 years ago requires that places of public accommodation must turn on captions upon request. And so far, that hasn't caused any problems. And, Maryland's gotten a lot of recognition across the country about the leadership, and other states have set laws that follow the model that Maryland has established. So really, it's just a logical extension here. We're just making the same principle. It's just applying it to movie theaters. Now, some of you do remember that I used to be the director of the governor's office of the deaf and hard of hearing for many years. And we already did hear from the current acting director, had already testified that Governor Moore supports this. So really, this is a no-brainer, truly. Now, before I was the director of the governor's office for deaf and hard of hearing, I worked at the National Association of the Deaf Law Center, where I did lead litigation on movie access all over the country. Now, many of those cases did involve NATO as well. Now, I can answer a lot of technological and legal questions about that, but really, I think the bottom line here is that this is just a continuation of the old bill from 10 years ago that has now become a law, and it hasn't had any problems so far. This won't hurt anyone. This doesn't cost anything. It's a no-brainer, so I do ask you to support this bill. Thank you all so much for your time.
Seeing no questions, thank you guys very much for your testimony. As you've heard, we passed this bill out last year. I know you're still in negotiations, Delegate Bhandari, so I do hope we have some success in the Senate this year. Make sure you use your energy there well. We do have a few virtual people to testify. Lisa Aran, or A-R-A-N, Aran. I'm not sure how we're gonna reach the virtual individuals.
We don't see anybody on screen.
Is there anybody in the wait? Okay, great. Go ahead, ma'am. You can go ahead, ma'am. I'm not sure if she's of hearing or not.
Yeah, can you focus the camera here again like you were before? Sure.
Hello, everyone. My name is Larissa Aranbeva. Hello again. My name is Larissa Aranbeva. I wanted to mention to everyone that I myself am a foreign individual, and several times I've gone to various movie theaters. And they gave me glasses for me to read the captioning. I already have my own prescription glasses, plus I had to put on this glasses device for the captioning, and it was quite heavy. The glasses kept falling down my nose, and it was hard to adjust it to read it correctly. At another theater, they gave me a small box to put on the table, or I had to hold it. And I would look up and down from the screen and look down to the captioning device, which means that I would miss some information. It would be much easier if the captioning was on the screen so that I was able to access both what is happening on the movie plus reading the captioning. I am hoping that we are able to make this open captioning bill a success for the deaf and hard of hearing community, as well as those individuals who have low vision. Thank you for your support.
Thank you, ma'am. Next, we have Matt Rice. He's not in the hearing room. What about Nathaniel Balsley?
There's somebody else.
Hello, everyone. I am here to express my sincere gratitude for the opportunity to testify before you all today. And this is in regards to the large benefit of having open captioning in the state of Maryland. To give you some background on my role, I am a deaf individual and I come from a deaf family I have a beautiful wife and 3 young kids. I consider myself a liaison between those individuals who go to open captioning films, as well as theaters in Frederick, Hagerstown, and the Baltimore areas. And I've been doing that for the past 5 years. I actually have a Facebook page where I let people know when specific films will have open captioning. And I have over 600 followers on that page. So there's a pretty large number. If I had not, volunteered in this role, there would be a large disconnect between individuals who want that open captioning and theaters. So I have been communicating between the deaf community and the theaters. I work with the managers at the theaters. And when people request specific films to have open captioning, I communicate that to the theaters. And then I let the individuals know when they're able to go. If there's a large number of individuals who want that open captioning, it's not just for deaf individuals, but it is for a large spectrum of individuals. Could be deaf people, people who lost their hearing later in life, or maybe they just enjoy the benefit of having the captions on the screen. I have been the middleman when it comes to providing those open captioning requests to make sure that the time is something that fits, people's schedules, something that's not super early in the morning. If the theater comes up with a time that is not a fit for most people's schedule, we will discuss with them and we'll try and come up with a time that fits with most people. And I'll ask them to post it so that it is available for individuals to buy tickets for that film specifically. Over the years, I've seen many people give positive comments on the theaters that they are going to. Some people have said, we haven't gone to the movies in a long time because my mom has lost her hearing, but now with the open captions, it feels like we are back to where we were before because we haven't gone in such a long time. Feels like we're back in our old days again. So my role, I've had the privilege to witness the positive transformation of those movie theaters and those spaces that serve the needs and preferences of all of those individuals, regardless of their hearing status. There has been an overwhelming support for open captioning from both the deaf and hard of hearing community, as well as from hearing individuals. And that shows that open captioning is a universal appeal, and there will be a wide impact on these with the open captions. I can personally testify that many open captioned films, there will be a large group of individuals that go. Those theaters are full of many people, and it's not just deaf people that are going. There's a lot of hearing people there as well. So there is a large interest in having open captioned films. So this is not just serving the needs of the deaf and hard of hearing community, but it also serves at the needs and enhances the overall movie experience for everyone. For the deaf and hard of hearing community, for those individuals who are learning English as a second language, those who are late deafened, especially, the boomer generation who are getting closer to that age where they may be losing their hearing, or for young people learning how to read. It can send a powerful message about the commitment of our society to be inclusive and have equal opportunities for all. This is a step to accommodate to various needs and contribute to a more compassionate and understanding community. And lastly, I really urge you all to consider the benefit of the open captioning bill and support this bill for the open caption in movie theaters. By doing so, you would be contributing to have a more inclusive landscape that would reflect the diverse needs and preferences of our community within the state of Maryland. Thank you for your time.
Colleagues, I do believe that does conclude this hearing. Again, thank you guys for coming. Thank you everyone participating. Again, I know that my committee will do its best to marshal this through, and I expect us to be successful again in this committee. So see what we can do in the Senate, bud. Thank you very much.
Thank you, Mr. Chair and the committee.
Next, we're hearing House Bill 271, Delegate Grammer.
Thank you, Mr. Chair. I think I may have one panelist in person and one remotely.
Brief indulgence. Have you guys paperwork? Computers. Sorry. And who's in your panel?
Gentleman from Maryland Legal Alliance and Charles Young Bar was online.
And is Joseph Lovelace? Go ahead, sir.
Whenever you're ready, Mr. Chair.
Nope, waiting on you. Go ahead.
Okay. Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 271. House Bill 271 requires a limited liability corporation to include in its articles of organization the name and home address of each member authorized to act on behalf of the limited liability corporation. Congress passed the Corporate Transparency Act, which went into effect January 1st. The legislation mentions specifically money laundering, the financing of terrorism, tax fraud, human and drug trafficking, counterfeiting, piracy, securities trading violations, and other known uses for malicious actors to exploit limited liability corporations. While I don't want to assert all those issues are happening here in the state, they probably are, but I think the committee should focus on one common thread among these transgressions: how LLCs are exploited to avoid their legal obligations. For myself, the issue is addressing community blight. For others who may speak today, their issue may be dysfunction in the real estate market. If a bad actor can use their LLC to disappear in order to avoid a legal obligation, enforcement of any law is impossible. This is in part a significant reason why I believe the Baltimore region suffers from so many housing issues. House Bill 271 attempts to help with this issue at the state level by including relevant contact information about members authorized to act on behalf of an LLC. This bill is slightly different from last year in that it provides the contact information of those authorized to act instead of actual ownership information. It also includes a framework for alteration of this information, a change identified by the State Department of Assessments and Taxation. This has been done in states such as Arizona, New York, and West Virginia, and we should adopt this simple transparency reform to empower communities and people who look to hold bad actors accountable. With that, I'd be happy to take questions, and I'd ask for a favorable on House Bill 271.
Good afternoon, members of the panel. Good afternoon, members of the panel. My name is Joseph Lovelace. I'm a staff attorney with Maryland Legal Aid. I'm based out of our Frederick office, our Midwestern office. And I want to start this brief monologue with a simple question. Who is your landlord? Now, a generation ago, maybe 2 generations ago now, that used to be a simple question. It was Old Man Higgins who ran the general store down the street. We all knew who Old Man Higgins was because he was also Santa Claus come Christmas time. But things have gotten slightly more complicated in the intervening years. Oftentimes, I will be representing tenants in landlord-tenant cases, and they have 3 points of context that are different LLCs. You have the owner, that's an LLC, and all we know about the LLC is who its resident agent is. You have the property management company, that is also an LLC, and in failure to pay rent type cases, you have a third LLC that is an LLC specifically designed to represent landlords in rent court. So you have one tenant with 3 different LLCs, and if there's a chink in this chain, there's a possibility for a lack of accountability, and I've seen it firsthand. If you don't know who is supposed to do the repairs, if you can't get from the property manager to the actual owner, you may not be able to properly enforce our rent escrow statutes. The reason why we're supporting this bill is it allows tenants to understand and very simply answer the question, who is your landlord? Because right now there's so much murkiness in the way that the laws are operating that it's impossible to actually know without actually filing a lawsuit and having access to discovery. But it may surprise you to know in failure to pay rent cases that are meant to be a speedy process, you don't have any right to discovery whatsoever. So in those types of cases that are the fastest in the state, you will have no opportunity to discover who these people are because there's no way to verify it without the tools of discovery as the law presently operates. And so with that, we obviously support this bill as we think it would be transformative in giving our tenants access to very basic information so they can answer the question, who is my landlord? And with that, we'd ask for a favorable report out of this committee. Thank you.
Thank you very much. And you said you do have someone who's virtual
Yeah.
on your panel?
He said he was in the room.
Right, 1 second. Is there Charles Youngbar in the room? Please put him up. Go ahead, sir, whenever you're ready. Sir, can you hear me?
Yes, sir. You talking to me, Mr. Youngbar?
Yes, sir. I apologize, Mr. Youngbar. You can go ahead.
Okay, thank you. Thank you for your guys' time today. Just want to jump on here and give a little bit of what we deal with on a regular basis with the LLCs. And Mr. Grammer and I have a lot of the same thoughts on this, something we deal with. I'm going to speak from 2 different points this morning. One is a realtor. My wife and I own a small real estate team in White Marsh, Middle River, Maryland. And also I am a title insurance producer, independent contractor with a title company for the state of Maryland insurance. And we see this a lot with our LLCs on a day-to-day basis in a lot of cases where the LLCs don't have a legitimate person or a legitimate address that you can get in touch with somebody. We see it in a couple fold from the aspect of even where there are ground rents that are recorded that are in an LLC holding, and then there's a lawyer or a person that isn't in some cases still alive that these LLCs are tied to. And I think it needs to definitely be fixed because what we see on a daily basis in real estate and the title is someone buys a piece of property, they throw it in an LLC, they start an LLC, and then they go open a bank account for it. And as long as they file their annual reports, all is good and carrying on. But even if they don't file their annual reports, they don't started a business, they've opened bank accounts, which there's no controlling over, they continue to operate under that. And there's just needs to be something to tie back. We see real estate deals that can't go through and hurt the public. And in a lot of cases, the public is those who get hurt because communities are affected. People will buy and put, I've seen in a number of cases where an LLC will be started. And then on top of the LLC that was started, that will link to another LLC. and then to another LLC, and it's almost like shell companies that just keep linking to someone else or links to a lawyer somewhere. That one I had the other day. So it's a lie. Was that bell for me, I'm guessing?
It was, sir. If you go ahead and wrap it up, thank you.
Yes, sir. Just thank you. Appreciate your time.
Thank you for your testimony. I do see some lights lighting up. So before this panel is excused, let's go ahead with Delegate Amprey.
Thank you, Mr. Chair. Delegate Grammer, so this bill, you said it's going back. So we have the CTA Act is passed, and you're saying that your bill is more focused on landlords. But your reporting would not just be landlords, it would all be all LLCs?
That would be correct. So just for clarification, everybody might not know, the other legislation was federal, much
Right.
more broad and comprehensive. We don't have access to that information. As you can hear, people talk about rent escrow, titling, code enforcement, ground rent, that tends to impact us at a more local level in terms of housing. But this it could happen anywhere. You could use an LLC to avoid any kind of legal obligation. And this applies it to all LLCs.
Right. So I'm trying to understand. It sounds like you're trying to ensure that tenants have access to a responsive landlord, which I think we all can agree we want a responsive landlord. My worry is that you're casting a wide net to put this over all LLCs. I'm trying to understand why not go through the process of requiring some type of reporting for just landlords? Like, why are we going for all LLCs? Why wouldn't we go and have some more stringent landlord laws or more rules around how the contracts have to be for leases versus trying to put all this on LLCs across the board?
I would actually have two comments. The first, I would say it's not just for tenants. It's for the individual who lives next to a property investor owns a single home and that home is completely neglected, but it's in an LLC. For an owner who lives in Montana, could be a community association has an interest. County government can't do its job because it just can't identify who to actually enforce against. So I think that the kind of person of concern could be anybody. The second response I would have is I don't think it is just if like a tenant landlord relationship. I don't think it's exclusive to housing, and I'm sure there are other facets of this that are not limited to just landlords. You know, I think last year there was a lot of comparison, comparing that. Well, why don't we just, what about sole proprietorships or like limited, other types of businesses that are formed differently. And the problem is that the structure of that filing is completely different. And that's the havoc the LLC causes. I don't know if you want to add something to that.
Yes, I mean, I think you raise a very good question. Why don't we just regulate landlords better? I think what Mr. Delegate Grammer made in his opening remarks, a very clear point, is that we can have very good laws on the books, but if our issue is that LLCs are trying to subvert them by either having fraudulent faces or, as Mr. Youngbar stated, becoming a shell game, they're just going to avoid those laws too. So we need to start at the source and get identification of who are we actually dealing with before I think we change the laws, because if we don't know who we're applying them on, or again, it becomes a shell game, I think those would just remain laws on the books. Like we have current laws in effect right now that we can't enforce properly because we can't identify who's behind them.
No, I hear you. I worry about the slippery slope here. And I think there's, with LLCs, there is a purpose as to why you want to shield your identity at times. There is a purpose for it, right? So, but at the end of the day, I understand there are bad actors using it for the wrong reason. And I just worry that with this bill, we might actually be overreaching. But I do, the intent of the bill, I fully understand. And as a Baltimore City resident who has a lot of vacant homes that are not taken care of, I totally understand where you all coming from. But thank you so much.
That's a huge point. And what we've changed to protect against that, last year we were asking for the name and address of the owners. This year, we're asking for the name and address of those authorized to act on behalf of the LLC, which is what other states use.
Got it. Okay. Thank you.
Thank you, Mr. Chairman. I had questions similar to Delegate Amprey, which I think you answered, but tell me again why this would be different than the resident agent. If you're saying you can't reach the resident agent, so you want another member authorized to act on behalf, or why can't you reach the resident agent?
Well, there are any number of reasons why you might not be able to reach a resident agent. For example, that information might have become outdated. Say the resident agent moved to a different state. They no longer are at the address.
You're not
that's
required to
part of
update
record.
that?
They are required to update it. Again, what we're trying to get after is bad actors. And if that information is out of date, your opportunity to go after bad actors is stymied. So that's part of it. The reason why you might want the information as to authorized to act on behalf of the LLC is also in landlord tenant type cases, especially at the district court level. The members or authorized actors of an LLC can represent the interest of the LLC without the assistance of an attorney, but there's no way to verify the person who actually shows up on behalf of the LLC is actually associated with the LLC and not just the resident agent or an employee of the resident agent pretending to be a representative of the LLC. And so this would get around that. So I could look up using SSTAT the way I already do to identify who are the names that could actually operate and represent this LLC in this type of proceeding, because there's just no way right now.
So if the resident agent information isn't updated, what makes me believe the authorized to act individual would be updated?
Again, I think we have the enforcement mechanisms to get that information updated. And I mean, I think what it comes down to is the authority between the two, because the resident agent's purpose is to be available for service. And I understand if that part's not working, why should we add more parts that might not work? But the information here should be more fixed. I'm going to assume we're going to have more names for who's authorized to act on behalf of the LLC. So we'd be able to have a wider net of people that we could work. If one doesn't, we go to the second, go to the third, go to the fourth.
And this bill actually does include an enforcement, a penalty.
Yeah, I
provision.
saw that. That was my next question. So you're saying up to a $5,000 fine. Is there a fine now for resident agent information not being updated?
I don't have the answer to that.
All right. And then did you say I know the feds, the FinCEN is requiring all this information as of 1/1/24. Did you say that's not available too?
So I believe that the way they've done it federally is that it all goes into a federal database, and I don't see any way, even as a state agency, to get access to that.
Not accessible by a state agency?
No.
And I'm not aware of any way to get that information either.
All right, thank you.
All right, we can go ahead and excuse this panel. Gentlemen, thank you very much.
Thank you.
I do believe we have a few other individuals here to testify. Well, one other individual favorably, Shauna Roth Gormley. I guess she's not here at this point, so we will now move on to the unfavorables. Paul Aiken, David Kahn. Please go ahead, sir.
Well, thank you, Mr. Chairman. My name is Paul Aiken. I'm here on behalf of the Maryland Land Title Association, which is a professional organization working on behalf of the title industry and service providers and consumers. And we are here in opposition to this legislation. The same form of the similar bill of 271 was proposed last year as House Bill 981. At that time, many stakeholders vehemently opposed the passage of the bill, and we rise in opposition as well. The bill would amend sections 4A204 and 4A207 of Corporation and Article of the Code, and requires the organization of a Maryland limited liability to include the name and home address of each member of the limited liability company who is authorized to act, and make it a misdemeanor to fall with the articles of organization that a person knows or has reason to know that there is incorrect information being submitted, subject to a fine of $5,000. We note that there are no similar bills in the Mid-Atlantic region that impose such restrictive oversights on private entities. Entities, for a variety of reasons, wish to keep their inner workings of the structure confidential from the public in order to avoid unwarranted solicitations, harassment, and security breaches. As mentioned earlier, the Corporation Transparency Act was filed federally and went into effect this January. We feel that almost all entities that are created have to follow the requirements of that act and to follow. Moreover, the LLC as created is so complex sometimes in our jurisdiction, and many participants in an LLC are uninvolved in the daily operations of an LLC. For example, if you have a member managed LLC, all of the members of that LLC are authorized to act and require separate authorization for any specific act. So it can get very complicated and intrusive on the members by having to identify their home address and the privacy of their names. Any required release would immediately threaten the reporting agent, of course, for lawsuits and dismissals. Finally, this bill only applies to LLCs. If I wanted to get around the requirements of this act, I would form a limited partnership. I could form an LLC, an LLP. There are several ways to avoid the tenets of the limited liability company, which is a popular means of protecting liability and shielding liability from the owners of the LLC. Finally, this legislation does not address foreign LLCs. So if someone wanted to be a bad actor, they would form in Nevada and be a foreign LLC operating in the state of Maryland. For these reasons, the Maryland Land Title Association opposes HB 271.
I'm David Can. I'm a partner at the Whiteford Law Firm in Baltimore, but here I am a volunteer as chair of the Business Law Section Council of the Maryland State Bar Association. And we oppose this for many of the reasons that my fellow panelists already expressed. So to answer some of the questions that were posed, the Corporate Transparency Act, which just started this year in terms of collecting data, that data will be available to federal, state, and local law enforcement to obtain from the U.S. Department of Treasury, FinCEN. And so it's not true that law enforcement could not get that information. What is true is that both under the CTA as well as a New York law that was passed last year, the information is not publicly available. It's to be used for law enforcement purposes specifically. That's a key distinction here because while there certainly are LLCs that own property, the vast majority of LLCs are not formed to own property and are formed for other types of businesses. So you want to be a service provider for your profession and you form an LLC to provide some protection for you. This would require that your personal address be available for everybody to know. Okay. I don't understand the idea that the resident agent is not sufficient. I serve as the resident agent for many different companies. Resident agents have obligations to make sure that the people that are responsible for the company get any legal pleadings and other government demands. If there is a problem, if there is a problem with old resident agents, then that is a different issue that should be addressed by the legislature to force dissolution of real estate holding companies that don't follow the rules. Rather than singling out LLCs. So for that and many other reasons, we oppose this bill.
Thank you, sir. See no questions from me and my colleagues. That does conclude this panel and this hearing. At this time, colleagues, I think that was our last hearing. We have an event tonight at Chop Tank. Please like to see as many faces there as we can, even if you can just swing by. Thank you guys very much.